Why did Tory Lanez not take the stand in his trial? That's probably a question you've been asking yourself. And so I want to address that issue in this video here. Before we get started, my name is Jamal Kersey. I'm the principal attorney at Kersey Law, a boutique criminal defense firm in San Diego, California. And in this video, we're talking about Tory Lanez's election to not take the stand and just some of the practical issues that surround a person who's accused of a crime, their decision along with their attorney to not ultimately take the stand. And so, I don't know Tory Lanez and, I don't know his attorneys. I obviously practice criminal defense in California, but, I don't know what discussions were had. And realistically, we'll never know because of attorney-client privilege. So his attorney's not going to speak on it. And if Tory Lanez is wise, he really won't speak on it either. So we just kind of have to put the pieces together based on, what we already know. And so the reality is there's a lot of bloggers, there's a lot of journalists, there's all kinds of, people who are just interested in this case in general who are speaking on this case. And, everybody's opinion on some level is to be valued. But at the same time, there are those of us, myself included, who actually are experts on the topic because this is what we do every day for a living. I practice criminal defense. I've been doing it for well over a decade. I've represented multiple people in firearms cases, attempted murders, murder cases, and people facing life in prison. And so, when it comes to being an authoritative figure on the topic, I consider myself to be one. And so even if you don't agree with my takes or my what I have to say, at the end of the day, there is something that needs to be respected in terms of, this being what I do every day. I've been in and out of courtrooms for a long time. And so, I'm not here to I'm not here to bash Tory. I'm not here to bash Megan. I'm not here to be pro Megan or pro Tory. I'm just here to speak on what I know and help give you some insight from the perspective of a defense attorney. And so from a practical standpoint, when it comes to a criminal defendant making the decision whether or not to testify, one thing that a person has to keep in mind is just the element of human curiosity, right? And so no matter what, we're going to talk about a little bit about what goes into voir dire, which is the name for jury selection. So the process of picking a jury from a defense standpoint, if your client is not going to take the stand, then oftentimes that's something that will be addressed in picking the jury. And so, but at the end of the day, that human element, people want to know. People want to hear from a person accused of a crime. They sit, the person who's accused of the crime just, sits at defense counsel table and they're, just basically sitting there the whole time. Sometimes they're writing notes, but when a jury doesn't get a chance to hear from them, they're left to sort of speculate as to, man, what would he have said if he had taken the stand? And that's something that, for me personally, because you have two different camps. One camp says, never put on your client on the stand unless you have to. And then the other camp would say, always put your client on the stand unless you can't. And I happen to be in the latter camp. I say, always put your client on unless you can't, because of that that element of human curiosity. I don't want to leave the jurors wondering in their mind what my client would have had to say. Now, if I can't put my client on the stand because, they're just going to bury themselves with their own testimony, or they're not going to come off as credible, or their story is not going to make sense, or any of those issues, then, obviously we'll elect to not put the client on the stand and then do whatever we can through cross-examination and calling our own witnesses in order to, put forth our defense. But ideally, if we can, I would love to, put my client on the stand any time. So, in this situation, again, with that human element, we address that in voir dire. And in terms of voir dire, what that is jury selection in order to ensure that your client, both your client as the accused and the people of the state, they want to have a fair trial as well. And so you end up selecting people who can be fair and impartial, given the facts, given the circumstances, and given what the law is. The reality is there are people who just simply cannot be fair and impartial if they hear certain facts or if they're presented with certain circumstances, and we need to have those people removed from the jury as soon as possible. Say, for example, you have a case where the accused is charged with a DUI. Right? If the person is charged with a DUI and let's say a prospective juror, let's say their son was killed by a drunk driver, right? So a drunk driver blew through a red light, T-boned their son, killed him on impact, and obviously their son is never coming back. For that person, just hearing of anyone driving under the influence of alcohol could trigger them into, a red rage such that they could never think clearly if they were presented with those facts. And there's no way that they could be fair and impartial hearing that, my client or, hearing that the accused is being charged with driving under the influence of alcohol. So for that person, there's a possibility that they could put that aside and still be fair and impartial. But a lot of times when you hear family members in that type of situation, they'll say, hey, I just admit that there's no way that I can be fair and impartial. And so, I just can't participate in this. And that prospective juror will be removed. So they have no business sitting on a jury if they can't be fair and impartial. And so that's just an example of one of the topics that's addressed in voir dire. But the one that I was going to mention has to do with a person and their decision to not take the stand and testify. Because one of the instructions that the jury will eventually get is that the defendant in a criminal case has the right to not testify. They have the right to choose not to testify, and the jury is not allowed to hold that against them because it's their constitutional right. So under the Fifth Amendment, you have the right to remain silent. And, you guys have all heard that before. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Well, that right to remain silent extends through trial and beyond. You have the right to not put yourself in a position where you could incriminate yourself. So that's something that the judge reads to the jury in the form of an instruction that, hey, the defendant has the right to not testify. You can't hold it against them. But us on the defense side, if you're an experienced defense attorney, you definitely want to touch on that topic with the prospective jurors, especially if you've already made the decision, if you and your client have already made the decision that you're not going to testify or that they're not going to testify, then you want to touch that topic. Why? Because of what I had mentioned in terms of that human element. Because here's the way I'll go about it. I'll say, hey, can I get a show of hands? Are there anybody out here who, if they were in my client's shoes, if they were charged with a crime, they absolutely would want to say their piece, they would want to take the stand, and they would want to clear their name? Show of hands if you feel that way. And there's always going to be a number of people who are going to raise their hands, and you select one of them. You say, okay, hey, Mr. Juror number 12, I saw you raise your hand. Can you, elaborate on your thoughts? What came to mind when the thought of you facing a charge and wanting to take the stand? What went through your head? And a lot of times they'll say something to the effect of, man, well, if I were charged with a crime, especially if I knew I didn't do it, I would want to take the stand. I would want to clear my name. I just couldn't sit there and be quiet while people are accusing me of something that I didn't do and blah, 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 blah. And that's a natural response, right? That is a natural human response to that question. However, the law says that you're not allowed to hold it against the client. You can't speculate as to what he would have said or what he wouldn't have said. if he were to take the stand, because, that would be a violation of his constitutional rights. And so, putting aside that opinion of yours or that position of yours that you would want to take the stand, would you agree that if my client elects to not take the stand, that you can follow the law and you will not hold it against my client? And to the extent, and most people are able to say, okay, yes, no, I understand. I will follow the law. I'm not going to hold it against the client. And we have to, ultimately believe that, right? But, I definitely believe that a person can follow the law. A person can want to follow the law and still have in the back of their mind that they would want to hear from the person that's being accused, because they themselves would want to take the stand if they were being accused, or that's just what they would expect from somebody who's being accused of, whatever crime. In this particular case, if you're being accused of having shot somebody, then, and you didn't shoot that person, then why wouldn't you want to take the stand and say, I didn't shoot this person, right? And so when I was talking about in my last video, I mentioned there was no testimony to refute Megan the Stallion's testimony when she said that Daystar Peterson shot her. Tory Lanez shot her. And there were people who I think were confused by this, because they were saying, well, no, there was all kinds of evidence that refuted her testimony. She had lied a whole bunch of times, and Kelsey had lied, and the eyewitness and all this kind of stuff. And really what that did was call into question what these people were testifying to. It was that, some of their testimony had been chipped away at, but there was never that direct confrontation or direct refuting of what Megan the Stallion said. And what that would have been either Tory Lanez himself taking the stand and saying, I did not shoot Megan Pete. I absolutely did not shoot Megan Pete. Or someone else taking the stand and saying, no, Daystar or no, Tory Lanez did not shoot Megan Pete. It's my understanding that never happened. And that's what the major problem was, it just wasn't enough to simply try and cross-examine Megan the Stallion, cross-examine Kelsey Harris, and, poke holes in their testimony versus directly refuting what Megan the Stallion said on the stand and what Kelsey Harris had said in her previous statement to the police. It just was never directly refuted. That is the practical issue that we end up addressing in terms of the person electing not to take the stand. But that is the very reason why somebody, I'd say that's the primary reason why somebody would not take the stand, is because they have a right to not take the stand, right? So again, under the Fifth Amendment, you have the right to remain silent. You have the right to be protected from self-incrimination. And the next reason kind of is along the same lines in terms of self-incrimination, and that would be the very fear that the Fifth Amendment protects, because you may feel like, hey, I don't want to take the stand because I may say something that does incriminate myself. And I think, in this particular case, that's probably something that would have happened. I think, just given Tory Lanez's rants on social media, the IG live that he had gone on, I think there really would have been a risk of him ultimately incriminating himself. And that would have been something, that him and his attorneys had discussed in terms of why it probably would not have been a good idea to testify, because of the risk of him either incriminating himself or making himself look guilty. Another reason why people can oftentimes elect not to take the stand and testify on their own behalf is just the sheer lack of confidence in either themselves and how they'll come off on the stand, or lack of confidence in their testimony. And sometimes this can be a situation where the defense attorney can really help in order to make the person feel more confident about what their testimony would be. And that's where, you're going back and forth and you're addressing how they come off to a jury. You're addressing certain questions. You're addressing things that that your client is going to have to hit on the direct examination. And I can definitely tell you that two main things that they would absolutely have to hit is, again, refuting Megan the Stallion's testimony where she said, Daystar Peterson shot me. So that's one. And then, 1A would be where Kelsey had, sent the text immediately to Megan the Stallion's security staff saying, hey, 911, Tory shot Meg. He'd have to address that. He'd also have to address, their own defense witness. Their own defense witness had said that they saw these flashes near the smaller gentleman, which would have been, Tory Lanez. It sounds like there may have been a flash near the non-victim female, so that would have been Kelsey Harris. So, there was a flash near her, and then there were about 4 or 5 next to the smaller gentleman. So that's something that he would absolutely have to address as well. You couldn't just omit that from your testimony. You'd have to confront that head on, because I can guarantee you, if he didn't confront it head on in his direct examination with his defense attorney asking him the questions, I can guarantee you the prosecutor would have ripped him apart by not, if he hadn't confronted it head on, and then it's on cross-examination would end up being the first time that he ends up addressing the topic of the muzzle flashes being, next to him, or, whatever the eyewitness ultimately testified to. So that's the thing that can be really concerning if the person doesn't have confidence in what it is that they're going to have to say. Sometimes, and unfortunately it shouldn't be, this ideally shouldn't be a factor, but it is. Sometimes people just are not able to articulate themselves or express themselves in a way that would ultimately be believable, and that plays in as a factor as well. Sometimes people, get really nervous or get really agitated in response to certain stress or stimuli, and that could call into question their credibility. But again, this is where, if the person knows what's coming, right? The defense attorney and their client have gone back and forth and discussed what the testimony is going to be. They know what the questions are that are going to be asked. They know what their responses are going to be, because, it's their truth. It's what they lived. Then ideally, if the decision has been made to move forward, then ideally that confidence is no longer an issue. It's always going to be nerve-wracking for a person to take the stand and testify when their freedom is on the line, especially the more high stakes the situation is. If you're talking about facing decades in prison or life in prison, the harder it's going to be versus, if you're just facing a mere misdemeanor charge where you might not even do time. But one way or the other, just being in court it's an intimidating process. It's nerve-wracking, and it's just not easy. I think the main issue, the biggest issue, would be the concern about being cross-examined, right? So, if you elect to take the stand, right, if you testify on your behalf, and again, I think the main things that Tory Lanez would have had to address is, being able to assert that he did not shoot Megan the Stallion, and, that she's either lying or she's just sorely mistaken when she said that he did. And same thing with Kelsey, being able to address that, he didn't shoot Megan, and being able to set forth the reasons why they're lying or mistaken, and and just the bases for that, and their motive to lie in that situation. There was a lot of lies being tossed around. The defense had put forth their alternative theory in terms of what they believe happened, that this wasn't him shooting her or him getting aggressive with her in response to an argument about his rap abilities, but rather this situation with this love triangle between him, Megan, and Kelsey, and the fighting between the two women, and all of that. And that would have been something that also that he could have addressed and elaborated upon, but obviously that didn't happen. But one way or the other, if he were to do that, then again, he would have been subjected to having a prosecutor who, knows their case like the back of their hand, just like the defense knows their case like the back of their hand. If once you get to trial, you've looked at every witness statement over and over and over again. You've listened to the recordings, you've seen the videos, you've gone through the pictures, you know the evidence. And so, you're subjecting yourself to getting grilled on the stand by a skilled prosecutor. And that can be very intimidating for some people, and rightfully so. And so if the defense attorney believes that, their client would just get eviscerated on the stand and get ripped apart during cross-examination, then that can be the primary reason why you say, hey, we're just not going to do this, because especially if your client is somebody who's going to lose their cool, if there's somebody whose buttons are easily pushed, if there's somebody who's easily triggered, emotional, then, a skilled prosecutor is going to be able to exploit that and, really trip them up and get them to say something that they really don't want to, and that can just blow up the whole case. And so ultimately, this is going to come down to the advice of the lawyer, right? The lawyer is going to be the person who's in the best position to be able to assess whether or not the testimony is going to be helpful, or if it's going to take away from the defense. At the end of the day, the defense is not obligated to, we already talked about how, under the Fifth Amendment, a person can't be compelled to testify. But the other thing, it just has to do with the burden of proof. The prosecution is the only the only party in the courtroom that has a burden of proof. The defense doesn't have to prove anything. And this is actually another thing that we address when it comes to jury selection, is that, hey, listen, you understand that we're not on equal footing here in terms of our burdens in this courtroom. The prosecutor is representing the people of the state of California by way of the district attorney's office, and they're the only ones that have a burden, right? So we could, and I'll just say, hey, I could just sit down and say nothing in this whole trial. My client could just sit down and say nothing. And, if they don't meet their burden, then you have to find my client not guilty. Now, obviously, I'm not just going to sit down and say nothing. I'm going to cross-examine the prosecution's witnesses. And if I have witnesses during my case of chief, I'm going to put forth, my witnesses and our case. But I don't have to prove anything to you. My client doesn't have to prove anything to you. It is on the prosecution to prove their case beyond a reasonable doubt. And so if the lawyer thinks that his client's testimony isn't really going to be helpful or even necessary, because sometimes your client's testimony just is not necessary. The prosecution's case can just be so bad that, it's not necessary for your client to take the stand. And so then you just say, hey, I'm not going to subject my client to cross-examination, to the possibility of him incriminating himself on the stand. I'd rather just, ultimately hold the prosecution to their burden, and we'll cross-examine their witnesses. We'll poke holes in their case. But sometimes, just merely poking holes in the case, like, what happened in this particular case. And again, this isn't, I don't have loyalty one way or the other. I don't have any, vested interest in the outcome one way or the other. But, my whole thing, again, is that sometimes it's enough to just point out the lies, the inconsistencies, and the holes in the prosecution's case. And sometimes it's just not. Sometimes you do have to come to the table and put forth an explanation so that you are able to clearly demonstrate that there is reasonable doubt in the case. And that's just not, what they were able to do. I think that the jury ultimately really relied on Kelsey's statement, her interview. So the interview versus her testimony in the stand. And I think that, they were able to set aside the lies, acknowledge them, but, ultimately find that her reason for lying made sense, on the major issues, and that she was credible on the stand. And so I really do believe that if, and I don't know, like if Tory Lanez did not actually shoot Megan the Stallion, then I think that's something that really would have been a helpful element to his defense, to be able to take the stand and say, I did not shoot Megan Pete. I absolutely did not shoot Megan Pete. And obviously there would need to be some sort of explanation or, reason given for these, flashes, these muzzle flashes and gunshots that were heard. They would need to be attributed to someone, right? Other than him. But that's something that would absolutely need to be addressed. It wasn't addressed. And so there was enough with what the prosecution put forward for the jury to ultimately find that there was no reasonable doubt. Now, there may have been some doubt because, and this is part of the jury instruction, that everything in life is subjected to some sort of doubt. But in terms of reasonable doubt, proof beyond a reasonable doubt is what they say is proof that leaves you with the abiding conviction that the charge is true. And that's what they were ultimately able to demonstrate on the facts of this case, that, the jury was ultimately left with the abiding conviction that Tory shot Megan the Stallion, and that's why they came down the way that they did. Let me know in the comments below if you learned something new. I hope you did. And if you got something out of this, please show me some love and hit the like button. Make sure you subscribe to the channel and make sure you turn on the notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.